would like to welcome the speakers of our first panel on anti-corruption and compliance, which will be moderated by AMADEU CARVALHAES RIBEIRO from Mattos Filho. Please welcome.
So, good morning, everyone. It's a pleasure, an honor to be at this great law school with these great students. And I'll jump right into the subject of our panel. It is, as you can imagine, just extremely difficult to speak after Justice Barroso. But I am fortunate to have, to level the playing field, there are 5 of us. So maybe 5 of us will do the trick. I'll make just a brief introduction. We decided to do this in a Q&A format to make it more interactive. And just a very brief introduction. You have the bios of the speakers in the program. You can read more about them, of course. We have here right next to me, Felipe Dantas de ARAUJO, who's a compliance and anti-corruption director at Walmart in Brazil. He has an extensive career in public service, which is, to me, is particularly interesting, the move into private sector, having had that great experience in public service. Then next to me, we have Christopher Levine, who is a partner at Shearman and Sterling, also with extensive public sector experience. Then to the far left, Jennifer Rogers, who is an executive director at the Center for Advancement of Public Integrity at Columbia Law School. She has also had experience with the public sector and remains in close collaboration with the public sector in the fight against corruption in the work she does. And then finally, last but not least, Elizabeth VICENS, who is a partner at Cleary Gottlieb, with extensive experience in anti-corruption enforcement matters, including in Brazil. As for myself, I'm a partner at Mattos Filho, a law firm in Brazil. I also do a bit of work in the compliance area, which is the topic of our panel today. So the first question goes to Felipe. Of course, you will think that these are questions that I wrote myself and they don't have no idea what I'm going to ask, but no, this is all orchestrated. We prepare the questions. So Felipe, and before I start, just a quick notice. Unfortunately, Jennifer, she has a flight to catch, so she will need to leave a little early. Before the panel ends. Just don't think that it was a question of mine that she felt offended by and left in outrage. That's not the case. So let's get started. Felipe, so Lava Jato, as we all know, gave rise to an unprecedented level of anti-corruption enforcement in Brazil. This led companies operating in Brazil to deal with anti-corruption compliance very differently. So tell us, what changes do you observe in this respect?
So first of all, when I decided to leave the government in 2014 and work for the private sectors, and my friends asked, what are you going to work with? And I said, compliance. And they said, what is that? So now, 3 years later, my friends know what I do. Even my physician now knows what I do. I mean, it's Brazil. In Brazil, compliance now is a matter of conversation, and everyone is aware. But apart from my personal life, that changed a lot in these 3 years, we can see in the private sector in Brazil that companies from all sizes were affected, right? Obviously, for big companies, especially multinational companies, as Walmart, as an American company, that already had anti-corruption and integrity concerns, the very decision to operate in a development country already brings the knowledge of the costs of compliance in this kind of scenario, right? And compliance as a business function, as a business purpose, has its costs. And in order to be properly executed and with the relevance that the courts will acknowledge, the companies must demonstrate that the expenses and the processes of compliance, they are risk-based, meaning that the level of commitment and the level of expenses is based on the risk of the market scenario where this company is going to operate. So obviously for these big multinational companies, operate in Brazil has become more expensive because of the increased compliance costs, right? But I have noticed change not only to big companies, but also to local companies. As Minister Barroso said, now executives, now powerful people have fear of being arrested. So it's visible when you discuss this in benchmarkings with executives, with operational executives of other companies, that now people have the personal fear of being arrested. Not only when they come to Disney, to United States, right, but also in Brazil, right? And also to smaller companies, you have seen an increased interest of smaller companies to get compliance programs, obviously adapted to their means. But another move is that big companies are also demanding that their service providers have compliance programs, right? So this generates, when you think in the market, in the supply chain of the market, this generates a chain of compliance demands, of contracts that have obligations that the partners, that the parties that sign the contract implement compliance programs. So this operates sort of a cascade of compliance obligations and compliance programs across the country, right? And we have seen it also not only for companies, but also for non-profit organizations. Those discussions have started to arise. So for NGOs who somehow get funding from the government or from other companies, they now are being demanded to have their own compliance programs. And even here and there, we start to see in the news or in some discussions of political parties wanting to implement their own compliance programs, right? So those briefly are the changes that I have noticed in the market.
Thank you, Felipe. Jennifer, would you like to talk about the subject of the lessons we can learn from U.S. companies, the U.S. public sector in the fight against corruption, based on your experience?
Sure. Well, I'm not an expert in where Brazil is as far as corporate compliance, but if it's been only about 3 years since people didn't know what compliance was in Brazil, then I think it's probably fair to say that U.S. companies started on this building up their compliance capacities a bit earlier than that. It's been about 15 years since the U.S. Department of Justice started getting really serious about FCPA and enforcing it. The UK obviously is into the act now with their Bribery Act. So for a lot of years now, a dozen to 15 U.S. companies have been really interested in building up their compliance programs. And so one thing I think that Brazil can learn from the states in that regard is looking at those programs and thinking about how Brazilian corporations ought to structure their own programs based on what the U.S. does. And that's not to say that it's one size fits all and you can just kind of look at a company and say, hey, I'm just going to pick up that program and put it into my company. It's also not to say that U.S. companies are the best at this sort of thing. But the fact that they've been working on this for longer and tried to beef these things up means that there are probably some good models out there. There's kind of I think a good news, bad news thing when it comes to working on a compliance program. The good news is there's lots of information out there. I mean, if you get on the internet and Google compliance program, you will find all sorts of guidance about what your compliance program should consist of. So there's a lot out there. The bad news is, again, you really have to tailor it to your own company and also be serious about it. You can't just hire a compliance officer and say, hey, we've got a program, we're done, we're good to go. You really have to be thoughtful about it. Your leadership has to buy in, and you really have to ensure that structurally it's built so that the compliance program infuses the entirety of the company and is put into place in a really thoughtful and deliberate manner so that you can really make sure that you're doing the best that you can do.
And how do you educate the employees of a company about the importance of compliance?
Well, I mean, training certainly is one of the most important elements of a good compliance program, and there are a couple of things I would point out. One is that you want to start your training with your biggest vulnerabilities. So, if you're a multinational company and you operate in countries that are riskier as far as corruption concerns go, then that's where you want to start, right? You want to look at that country, you want to look at what employees you have there, and then you want to start with those employees in that country who are the most at risk, who deal with the foreign officials, who are then at biggest risk of being bribed, that sort of thing. So you really want to, again, be deliberate about it. You want to start your training and education with the employees that, frankly, might get you into trouble, the most trouble, and the soonest. But training has to cover the whole company. It should be, there are all sorts of parameters. It has to be thorough. You should do live training. You should be at least annual for your most important employees that have the most risk. So there are all sorts of things you can do. But again, the point is to really be thoughtful about it and to pinpoint where your riskiest areas are and then work out from there until you have a comprehensive training and education program. And the other thing I would say is that, there's a cliche, tone from the top, right? You have to have a tone in your company of integrity and ethical behavior. It has to kind of emanate from the top down and spread throughout the company, and it can't just be the cliche, right? You have to actually work at it and make sure that you're really trying to have your company be transparent in the way that it operates and have ethical standards that go through the whole company.
Thank you. Liz, would you like to maybe weigh in?
Absolutely. Apologize. So I echo a lot of what Jennifer said. I was taken, by Justice Barroso's comment about 1976, and that being the year when he started his career and when we started to see changes in Brazil in terms of its democracy. Well, that was also the year that the FCPA was enacted in the United States. And so, you've had 3 years of the Clean Companies Act, I think. Less than that since the Programa de Integridade was implemented by the CGU and compliance guidelines were provided to Brazil. In the United States, we've been living with this for 40 years now. And I think that it absolutely is the case that, while there isn't, I don't think that there's one size fits all, and I don't think that it is the case that the United States knows how to do this better. I think that these are really tricky issues. When you're talking about corruption, a lot of the times, you can have a really, really great internal controls program and policy on paper, but it's people who are overriding that, management that's circumventing those controls by acting outside the organization for their own interest that can really, make it difficult both to catch that type of conduct, but also to figure out how to address that from a compliance perspective. And I think that's particularly what we've seen in Brazil. You've seen doleros and third parties where, you have complicated schemes to enable bribes to be paid to government officials. And what I think we've learned in the United States is when Jennifer talks about tone at the top, it does sound cliched, but it is about creating a culture of compliance, about saying even those people at the top are not, are not allowed to just act as if they can circumvent or as if controls don't apply to them. Everyone in the company is responsible for complying, and that's going to be consistently implemented. And I think it's about also not just saying these are rules on paper, but also saying that this is actual policies and guidelines that are implemented into our culture and that we have to actually do more than just have them on paper. We actually have to implement them.
Thank you. So I wanted to move back to Felipe, if you'd like to weigh in on what was just said, but Also give us your perspective on the role of in-house counsel and compliance officers in doing all this work.
Sure. Just to give a couple of thoughts on proper measures of a compliance program. If we take a step back and before thinking on compliance, if we think on pure core business functions, we see that companies and overall business administration, they have been very successful in transmit to their organizations things like culture, business vision, business purpose, and if you dig into a company's vision, if you dig into a founder's vision of a company, there's always something good, right? There's always the creation of a product that's going to turn people's lives better. There's always the foundation of a service that will revolutionize some aspect of society. And these are good things, right? The best examples of compliance programs that I have seen are programs that take this worldview, this good worldview of the companies and embed integrity and embed compliance processes in this worldview and transmit it to the employers, right? Because the employers, they already are accustomed to see and to be stimulated to be proud to the vision of the company, right? So let's add integrity to this vision. Those are my last comments on this piece. On the roles of in-house counsel and compliance in the organization, so taking a step further and entering into the compliance scenario, and this is a remark that's good both for Americans and for Brazilians, right? We need to have in mind that the type of capitalism in the U.S. is different from the capitalism in Brazil, meaning that if you look to the structure of the companies in the U.S., we have more shareholders, we have disseminated capital, we have sort of a corporate law that has evolved organically to protect the shareholders. And with this organical evolution, the compliance process and programs was something natural to be added on. Brazil is different. Brazil, we have a lot of state-owned companies, we have a lot of state funded companies directed by pension funds, and we have a lot of family companies. So it's a more hostile scenario to have an independent compliance profession working, telling business people what to do and not to do, right? And we still have, thinking on the difference between legal and compliance, we still have some challenges to put a threshold. What is the role of legal counseling and what's the role of compliance commands and policies and internal policies, and even for professions, right? I mean, if you guys want to be compliance professionals in Brazil, you must have some sort of courage, because you are not lawyers, so you're not entirely protected by courts or by attorney-client privileges, and the criminal role of the compliance profession as someone that guarantees that the company is not going to practice a crime is still going to be under debate. So those are the differences.
Thank you. Chris, you've been silent so far.
It's a rarity.
Yeah. Would you like to weigh in?
No, I think those are really good points. I mean, one observation I can make in terms of differences between lawyers or external counsel and internal compliance folks is we see more and more, at least in my practice, I don't know if others have seen the same, that a lot of big institutions, a lot of multinational corporations actually recognize the benefit of having compliance folks on the ground. So, for example, if an issue happens, the first people on the ground, the first line of defense, are people who actually work for the company, are familiar with local customs and laws, and they can go in, do kind of a quick deep dive to assess the situation, and then, depending on what happens, figure out whether or not to loop in external counsel, and in the course of that, they're communicating with in-house counsel. I think that's been a little bit of a change over the last few years. It used to be the case that if there was any type of issue that got reported, oftentimes external counsel would get brought in and do an internal investigation. I think it's a product of a couple different things. I think it's one, the culture of compliance that Jen mentioned, where a lot of companies just really are taking these obligations very, very seriously. And if there's a whistleblower complaint or an issue that's been escalated to somebody, the company decides we have to do some sort of investigation, and the first line of defense will handle it. I think that just happens so much. There's such a high volume and cost of bringing an external counsel to do these investigations. They'll rely on, the folks on the ground who work at the company in compliance. And second, which I suspect I'll talk about in a moment in response to a possible question, is I think that's very good, because I think people who are on the ground, who reside in that particular country, oftentimes are the best people to ask the questions, gather the facts, and do all that.
Yeah, so why don't we move to the topic of internal investigations. The topic obviously goes hand in hand with compliance. What I see in Brazil in particular today is that because of the enhancement of compliance programs, you see more and more employees coming forward and telling things that they have seen, and this act of coming forward is precisely what may lead to an internal investigation. So tell us a little bit about the pros and cons of conducting internal investigations, and how does it compare, if you can offer a comparison between the U.S. and Latin America, the pros and cons?
Certainly. So, the standard answer is there are no downsides to doing an internal investigation. And, look, I'll kind of level with everybody. From a practical standpoint, there can be a number of downsides to doing an investigation. Those are costs, those are, possible issues that one can create with the employees, and I'll speak to those. But on the whole, speaking from a U.S. perspective, those really, really, really are outweighed by the pros. And again, I think it's a huge product of the environment we're in now, just to the reality that it's expected. From a perspective of the culture of compliance that Elizabeth was talking about, it's the right thing to do. Jen and I had the privilege of working at the U.S. Attorney's Office together, and one of our old bosses used to always say, integrity means doing the right thing when nobody else is looking. And, you have these policies, and it's true, and it's something, I oftentimes think about when sometimes you get these issues posed to you as a lawyer. But at the end of the day, everybody talks about having a good policy on paper, and you have to have it actually be implemented very well, and that goes without saying. Internal investigations, I think, can be a situation where the rubber meets the road. You have this policy, it's been vetted by counsel, you've done your trainings, everybody's certified and signed that they've reviewed the trainings and they understand the policies and they know what to do. Well then, lo and behold, somebody comes forward and makes really, really, really serious allegations about upper management at a subsidiary or in the United States, and compliance is then posed with the situation, what do we do? And there, conducting an investigation is really the right thing to do. Number one, you can find out the truth. Number two, you can gather the facts. You can figure out if this is an isolated problem, if it's much, much, much broader. You could have a segment of your business that's engaging in rampant fraud. So just getting the facts and getting the truth, first and foremost, I don't see a con to a situation like that. You figure out the facts, then you figure out what to do. The second point, which I think everybody should bear in mind, is if you don't do this, putting aside the message it sends to the employees and how it's not a tone from the top in culture of compliance, eventually, these things metastasize and they get bigger and bigger and bigger. And if folks have read about some of the recent scandals, even Wells Fargo, a lot of people are harping on the fact that this was brought to the attention years and years earlier. So you don't want to create a record like that. Mm-hmm. Those are the pros. The cons, it's a reality, the practical concerns, it obviously can entail a lot of costs. The more and more of these investigations you do, especially if you bring in external counsel, I've seen this firsthand. Sometimes employees really feel like their employer does not have their back. So it's just a reality. It can, create some dissension there for the company. But again, on the whole, I think those really are outweighed by the pros. In terms of difference between the United States and, Latin America, including Brazil, the U.S., I think this has been going on for a number of years, so people in some ways kind of get the drill when external counsel comes in or when compliance comes in. I think some of the practical challenges sometimes dealing with Latin America or any country for that matter are, number one, there's always cultural barriers. It's just a reality, and I think to do an effective investigation, you need to appreciate that. You know, you need to work with the folks on the ground. You know, somebody like, you know, Felipe, who's there, who's familiar with the employees, who's familiar with the customs, just to show that you're respectful. And people can take certain ways U.S. lawyers question differently. Practical considerations, there's a whole different kettle of fish when you're dealing with overseas. Sometimes there are very stringent data protection laws, data privacy laws. So if it's a foreign subsidiary, you're down there, you have to be mindful of that and respect that. And this can really result in crazy situations where, for example, you know the facts, you talk to the employees, but given a jurisdiction's secrecy laws, you can't, you have to limit what you can disclose or mask it to regulators. So those are just some practical difficulties and realities that can come up between the two jurisdictions.
I would add, maybe with respect to Brazil in particular, is what happens to the work product of your investigation. There's, and I'm not saying that this should lead to a decision not to do the investigation, but it is a risk factor, namely that the authorities will want to see the work product of your investigation. So the privilege around investigations is an issue in Brazil today. But Jennifer, would you like to offer some comments on what Chris just said?
Actually, I honestly think he covered it really well, so I don't really have anything to add. Do you have anything to add, Lisa?
Yeah.
No, I mean, I think the only additional point I was going to make was the one AMADEU just meant, which is, not only the importance of governing the privilege, protecting the privilege with respect to potential requests from authorities, because I do think that the decision to investigate is very different and separate from the decision to self-report. Those are two different decisions, two different processes. But I also think there's also differences between the privilege and how it's construed in the United States versus Brazil, which you're going to want to be mindful of and make sure that you're conferring with local counsel, Brazilian counsel, to understand those differences.
Yes. I completely agree. And since you have the microphone, can I move now to the subject with a question to you we touched on internal investigations. Let's talk a little bit about government investigations, and in particular the volume of collaboration that we're seeing between the U.S. and Brazilian authorities these days. How is this working? In what ways is cooperation increasing?
Well, I think that it is very definitely on the rise, and we've seen that, right? We've seen that in the recent Odebrecht and Braskem resolutions, global resolutions, with the United States, Brazil, Switzerland, which has really strong secrecy regime, so that's, remarkable in and of itself. But I think that not only have we seen it, and it's interesting, taking Odebrecht as an example, how we've seen it, right? Like, it's clear that the authorities have been collaborating and cooperating, and I think that, as I did not work for the government, I've been doing defense work for over 10 years in the region, and it's my bread and butter. But what I think that I tell my clients nowadays is you have to assume that they're cooperating. You have to assume that they're speaking with each other, and if you're dealing with multiple regulators, that anything you say to one can be said to the other. And one part of, defending companies is understanding that that's happening and making sure that you're doing the best to position your company to effectively cooperate with all of the authorities that have jurisdiction over your client, and that you're able to effectuate a global resolution that gives them peace, global peace at the end of the day. But it is interesting to see the trend toward cooperation, in addition to Odebrecht, Braskem, Rolls-Royce, Embraer, other resolutions in Latin America in the last year, including LA and SQM. Those all have been global resolutions involving multiple regulators. And not only are they cooperating in terms of providing information to one another, but also in stepping back if they need to. Odebrecht was really a Brazilian-led investigation, and 80% of that fine went to Brazil. We saw when the DPA came out in the United States, a lot of the information was sealed or confidential. And that was to allow the Brazilian authorities to continue their investigation. And we saw just a couple of weeks ago a huge number of additional, I think 88 warrants and that were allowed in connection with plea agreements in Brazil that came from information obtained through Odebrecht that had been basically kept sealed so that the Brazilian authorities could keep pursuing those investigations. And so it's been quite remarkable. I think we're going to continue to see it, and I think it's something that has to be very present on the minds of Brazilian companies and those who are representing them.
Thank you. Chris, comments?
No, I agree with everything that Elizabeth said. The reality is, United States Department of Justice, it's the Department of Justice of the world. They seem to think. And you see them stretching into so many different areas, not only regions, but actual areas. I mean, you look at the BNP Paribas guilty plea, and many French citizens, some would say rightfully so, were up in arms that this French company, which has French citizens as the primary shareholders, is going to have to pony up billions of dollars for conduct that violated United States sanctions laws and ostensibly some United Nations resolutions. But, at the end of the day, it was United States law, and they were not on U.S. soil. Now that, has been resolved, but I think that's just emblematic of how the DOJ is, especially in investigating corruption. I think the one situation where things can get sticky, and I agree with everything Elizabeth said, you have to assume if the United States Department of Justice is involved in an overseas investigation, particularly in Brazil, there's some level of cooperation. If there are interviews in Brazil, there is cooperation, 100%. Where it can get sticky, though, is where you have U.S. lawyers meeting in the U.S. with the DOJ, typically the SEC, and the foreign authorities are not there. And then the prospect of cooperation comes up. That's being discussed. If you ask DOJ point-blank questions sometimes about whether or not they're going to share that with the Brazilian authorities, you'd be surprised at the ranges of responses you'll get. So one practical consideration, kind of in the nuts and bolts, is that's where it can get a little sticky. Because DOJ rarely can promise, in practice sometimes they will, that whatever information you provide to them, they will not share with their Brazilian counterparts. So that's a situation, to the global resolution point, you have to navigate some minefields.
Oh, I agree, and it's an important point. So we know there's ongoing cooperation, but I think, to me, the most interesting development is one that Elizabeth touched on, which is the settlement of Odebrecht and Braskem, and I wanted to turn to it a little bit. Is this a trend that we're to see, that we will see in the future in these cases? I found it I was surprised to see that kind of settlement involving at least 3 jurisdictions and the fine being split among jurisdictions. I do, my primary practice area is antitrust, and there we see in cartel investigations the opposite trend. You see jurisdictions really willing to establish their authority over a matter and fining the companies regardless of whatever fine that company may have paid elsewhere. And then you see the fines piling up, and one of the big I think complaints that companies have is this is going too far. So 2 questions for you. Are we going to see settlements of this nature as a trend in, say, government enforcement, and is this a good thing for companies?
I think I would say yes to the first question. I think we are going to continue to see this. And, I think that it's a couple of different factors that maybe differentiate it from the antitrust context, which I think are important to remember here. Just the nature of a lot of these cases are international. I don't think Odebrecht was a Brazilian bribery scheme. I think it's fair to say Odebrecht was a Latin American or even a worldwide bribery scheme. It touched on just so many jurisdictions in so many countries. And it required cooperation in order to mount a case like that from so many jurisdictions. And I think that that is a hugely important distinguishing factor. The FCPA, and just by its very nature, involves conduct that has taken place abroad. And so for the United States, that has been a real challenge. How do you mount investigations where a lot of the evidence that you're going to need to rely on doesn't exist within your jurisdiction, it exists outside your jurisdiction? So there have been a couple of ways that U.S. authorities have tackled that issue, through whistleblower programs and through cooperation with foreign governments. On your second question, which is this good for companies, is this bad? I'm going to take the easy way out and say it's a mixed bag. I think that in some ways it is good for companies. When you talk about, another distinction between this and the antitrust context, which is that you see apportionment. You don't see jurisdictions jockeying as much to each get the largest fine possible extracted out of those they are settling with. Instead, what we've started to see is apportionment of the fines, and I think that can be a good thing. Again, I think it can also be a good thing for companies if they are able to obtain global peace, if they are able to negotiate a settlement that doesn't just resolve an investigation, which, as Chris mentioned, can be very costly in and of itself with one regulator, but can actually obtain a resolution that will end investigations across a number of regulators. That's a good thing for companies. On the other hand, I do think that it can create a lot more complications for governments when they are being investigated by multiple authorities and when they are trying to negotiate those types of resolutions. Again, it brings a lot of issues into play, including privilege, including getting, having to have different counsel in each of these jurisdictions who can explain to you how the laws in those regions work, what the regulators are going to expect, and how to best position yourself. And I think that there's a lot of very distinct aspects to Brazil in particular, just speaking from experience and navigating how to effectuate a resolution involving Brazil, because you can talk about having different regulators across different countries, but in Brazil, when you're talking about the Clean Companies Act, and when you talk about LAVIGNE, you have numerous regulators just within Brazil itself, and how do you manage that process as well? So there's a lot of, I think, good things for companies, but I think this does increase the complications as well.
Thank you. Felipe, would you like to give us the Brazilian perspective?
Yes, please. Taking Liz's last line, I believe that it's sort of paradoxical that we see regulators from different jurisdictions being able to cooperate, but regulators inside Brazil are unable to cooperate when it's related to leniency agreement and settlements, right?
Hear, hear.
So, to give a brief overview of where this matter is now, the BCCA created a leniency agreement and allocated it into the Office of the Comptroller General. But there are other regulators that have constitutional mandates that were not part of this initial draft of responsibilities. So we have the Public Prosecutor's Office, who is responsible for crimes against physical, for crimes committed by physical persons, but also for we have this, it's called in Brazil the impropriety actions, which are sort of class actions that government can use to impose fines and collect damages from corruption cases. The damages part also that the Office of the Attorney General, the AGU, has constitutional mandate to collect is outside of the scope of the leniency agreement, and the TCU, which would be the count of accounts, the superior court of accounts, that also oversees anything that is related to public funds, is outside of the original draft of the BCCA. And we have seen in 2 years all those organisms, all those regulators like fighting, like dogs for a piece of meat. Hey, no, I want this piece of the deal. I want that piece. I want the protagonism. And it's really sad that sometimes it looks like it's just an ego dispute, right? It's a dispute for protagonism. But and to finish my remarks on this, it's also very sad that in the Odebrecht depositions that were released to the media last week, for me it's the most ironic part of the deposition, that the owner of the company, he said that the leniency agreements in Brazil is so murky that they needed to bribe the government again to try to pass legislation to get that fixed so that they could negotiate with the government. That for me was the most ironic part of last week's the t-shirts.
Yeah, well, let's try to then move to a more positive tone, getting Chris's perspective on the leniency policy. And we know, let's think about the scenario we've been talking about, the internal investigation. Let's say you do an internal investigation and you learn about facts that essentially represent a violation of some law. You would like to collaborate with the government in exchange for a reduction in the penalties or in total and complete immunity from sanctions. What comes into play when you're doing that assessment, whether to cooperate or not?
I think it's a great question, and it's really one of the most difficult questions for a company and for a lawyer advising the company. In some instances, it's relatively easy because the problem's so bad. You want to self-report, but the decision of whether or not to self-report has a lot of different, layers and factors. Taking a step back, it's not necessarily a new landscape. In the United States, we have an adversarial system. I mean, it's based upon if, the government believes somebody committed a crime, they can charge, and that person has the right to defend themselves. And we see that happening, every single day with various individual cases that are brought. I think the Department of Justice has done a good job in publicly espousing principles it's going to use in deciding whether or not to prosecute a business organization. Because the reality is, as a matter of United States law, it's not that hard to do. It's not that hard to do. You don't need to have certain people know in order to establish the company is guilty or liable. It's not that high of a hurdle. If you have an employee who's essentially acting for the benefit of the corporation, subject to some other factors, the company can be charged. And when the Department of Justice and a lot of other regulators have followed suit, like the New York District Attorney's Office, for example, when they're deciding whether or not to exercise that discretion and what penalty to impose, they look at a handful of factors, 13 factors. And if you actually read them, they're public. I'd say about half relate in some way, shape, or form to cooperation, or self-disclosure, or remediation. And the question oftentimes, is posed to counsel, okay, number one, is this a crime? Is this a violation? And if the answer is yes, then you have to figure out, is it better to get in front of this or not? And oftentimes, there's a big premium placed on self-reporting because you can hope that the government is going to use its discretion and not charge. And this happens in a variety of different contexts, not just DOJ, but OFAC, SEC, and basically appreciate you coming forward with it. So, the biggest benefit to taking that approach is you can stave off or avoid a charge altogether or get a substantially lower fine. Now, you have to, it comes down to a question of judgment. And with financial institutions, there's so many different regulators. You have the Fed, you have the OCC, you have DFS. Every agency has different approaches and offers different guidance on what should be reportable. And it really boils down to a question of judgment. Now, the downside is this adversarial system I was talking about. Sometimes it feels like there's no judge. It's the Department of Justice. And we're talking about the FCPA and some of the internal controls provisions. You know how many court cases have actually interpreted those statutes? Like none.
Yeah.
So, the DOJ really is prosecutor and judge because they lay out guidance as to whether something, is a prohibited payment or not. And we take that guidance and we advise our clients accordingly. But the reality is courts really haven't opined on a lot of these issues because the posture and the normalcy of these types of cases is you find a potential violation, you self-report, you negotiate a disposition, and it's worked out. Now, is that good? Is that bad? I mean, I think Elizabeth touched on that well. I think Jennifer touched on it well. I think Elizabeth touched on it very well in terms of, how you can get certainty, how you can reach global resolutions, but, it's always a tough call, always a tough decision point. I think the reality is, if you just look at the public record, most companies do. And, a lot of Jen and I's former colleagues, who get out and talk about this, one of the big points that's made is what really is the benefit to cooperating? Because every year, if you read the SEC annual review, the fines are higher and higher and higher and higher, and everybody's cooperating. So eventually you have to ask yourself, it's basically taken as a given. If you don't cooperate, and if the government finds out on its own, that's when they're going to make a real example of you. And I think, candidly, that's one of the main driving, motivating forces of a lot of these self-reporting, because a lot of companies don't want to be that person that's made an example of.
So, Jennifer, Elizabeth, would you like to add to what Chris just said?
Yeah, I'll just say one thing, and then I do have to go, but it's definitely true. There are no cases, there's really no litigation interpreting this statute, and so, I mean, someday they're going to push hard enough that some company is going to say, forget it, we're going to court, and we're going to see what happens, and maybe we can get this provision thrown out or narrowed in some way compared to what the DOJ says it is. So I think it will happen because they are pushing, which is their job, and that's what they should do. But it's going to come, and someone's going to, decide to roll the dice because, no one's been challenging these provisions at all, and so I think it is going to happen. I mean, if I were a private sector person like Chris or Lisa and I were advising these companies, I think that is, of course, the big ticket question, and it's very hard to advise them the right way, and it is a judgment call. At the same time, no one's advising them to go ahead, or maybe they are and the company's deciding not to do it, who knows, but everyone's deciding in the same direction, so I do think at some point someone's going to just put their hand up, and then we'll see. We'll get some litigation of the FCPA, and we'll actually see what these provisions are as far as their breadth, because right now there's just there's nothing that's happened in that regard.
Thank you, and have a good flight.
Thank you.
So just following up on that, and thank you, John. I just really one small comment, which is for those of you who are ingrained in this subject, about a year ago, the DOJ instituted a pilot program, and the idea of the pilot program was exactly to address this issue of transparency, of how, as a company, are you able to assess whether and to what extent your cooperation will impact the ultimate penalty that is assessed against you. And so, we've had this pilot program in place now for a year. The Trump administration recently in March said that they would be extending it and further evaluating it. But I think there's been, some benefit to it in helping this issue. Now, in connection with resolutions, the DOJ actually identifies what were the factors that made it, depart from the sentencing guidelines, either in terms of, providing a reduction, what was the level of cooperation, the remedial efforts, the self-reporting that the company did that helped reduce the penalty assessed against it, and why didn't the reduction go as far as it could have? What did the company fail to do? And so that has been helpful. And in addition to the announcements of the resolutions, we've also seen 5 declinations, 5 instances where the DOJ, since this pilot program was instituted, has said, you know what, we have sufficient evidence here that we could charge this company, but we're not going to, because they've done all of these things right, and here's how they did them. And those have also been helpful. But I think there is still a lot of murkiness from the perspective of companies in trying to understand exactly what they need to do and how much of a material impact that's going to have at the end of the day in their negotiations.
Thank you. From my perspective, I'll just add one thing. perhaps as important or maybe even more important than the level of the fines is the issue of predictability, especially in Brazil these days. If you are considering whether to cooperate or not, the first thing you need to know is who am I talking to and where is this going to lead? So you need to know what the end game is. You need to have some level of predictability about the end result. We do have, I think, a lot of transparency in the antitrust area with respect to the end result. You know exactly what's happening when you step in and you tell the government, I'd like to collaborate. We have maybe less transparency when it comes to the anti-corruption enforcement, and that's what I think authorities need to work on. I'm not saying this is not meant to criticize the system. It's really being born, the system, and to me that's the one aspect people should work on. Knowing what the fine is, regardless of the size, is perhaps more important than the fine itself. So maybe we could move now that Jennifer left us. A question for Chris. We would like to know more about the implications of the Yates memo. For those, I'll tell you, you will, of course, be able to explain what the Yates memo is better than I can, but essentially, I think it raises issues for companies and employees. The notion put forward by the Yates memo, namely that one should look more closely at the level of culpability of employees and in some instances, not offer them the same level of protection that one could previously have hoped for. Does that create an issue for people who are active in the area of government enforcement? How does that affect the situation in your work?
A lot, to be blunt. And you know, my practice is primarily in criminal defense, and I represent companies. I also represent a lot of individuals, individual employees. So I can certainly speak to that if anybody has questions or is interested in it. Happy to talk with you folks about it. I don't know how much folks know about the Yates memo. At a very high level, the Yates memo was in response to a lot of criticism of the Department of Justice over the last 10 years, especially in connection with the financial crisis. I mean, you know, you do a Google search, there's a lot of criticism and people who are upset and public officials who are upset with the fact that no individual executive has been successfully criminally charged and convicted in connection with the United States financial crisis. So there's been a lot of upset people about that. However, if you look at the record in terms of getting settlements from financial institutions, it's in the billions of dollars. I mean, looking at certain institutions alone, $10 billion fine. So there's a lot of, you know, criticism about certain of these banks are, quote, you know, too big to fail, and rather than hold anybody individually accountable for it, the financial institution has to pay a huge penalty, and the net effect is the shareholders suffer, employees suffer. It's an ongoing debate. The Yates memo, in my opinion, and with the U.S. Attorney's offices I deal with, I don't think it represents that big of a change of a policy. But essentially what the policy says is in order for a company to get, quote, cooperation credit, which we've been talking about a lot, it has to provide all information relating to all relevant facts relating to the culpability of the individual employees. So as a practical matter, if somebody does choose, if an entity does choose to self-report, and we're making a presentation to the DOJ about it, about why not to charge, or about why a low penalty is warranted, when they look at cooperation, they're not just going to look at the fact that we're in there, we're presenting, we've turned over documents, we've made witnesses available for interviews. They also want to know if we have provided all reasonably available facts about individual employees. Now, you know, that was in many ways, I think, a common practice. The Yates memo just put it down on paper. And how that changes things, I can give you two key examples of how it changes things. You know, one is if you're representing the company, it has a natural built-in, I don't want to say conflict, but potentially diverging interest between the company and the employee. Because the employee, if he has his own individual counsel, and this is how I advise my individual clients in situations like this, have to be aware that what this individual employee says to the company's outside lawyers, high likelihood it'll be disclosed to the U.S. authorities. Very, very, very high likelihood. So when you come in and you want to have the employee cooperate and you want to say, you know, hey, Bill, tell me what happened. You know, tell me what happened. You know, when you wrote this email, what does this mean? Now, if you're Bill, and if you know you were involved in something really, 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 really bad, and you have a good, competent defense lawyer, you know, you're faced with a little bit of a dilemma. If you don't cooperate, depending on what the, you know, agreements say, you might be out of a job. If you do, there's a very good chance when the company reports to DOJ, they're thinking about themselves, we want to get cooperation credit. You know, he could be served with a grand jury subpoena, you know, weeks down the road. So that is one issue that I think is really, really, really front and center. And before, you know, AUSAs and prosecutors would maybe vary on how much they were going to press that issue. Now with the memo, it constantly comes up. So when you go in and present, they want to know exactly, well, what did the individuals do? What did you find? What did he say? In the course of that also creates an issue about privilege, which we've spoken about, because technically those interviews with the employees, they are privileged. They're privileged communications, but the privilege belongs to the company. Privilege belongs to the company. So it gets into a little bit of a complicated question about how much you can disclose to the DOJ to get the cooperation credit without waiving the privilege. But from an individual employee's perspective, much, much, much more heightened concern that cooperation with your employer at the end of the day is going to result in disclosure to the U.S. authorities. And that adds to what I was talking about earlier, some of the practical, you know, realities and consequences of doing these internal investigations. The employer and the employee relationship can be strained. And the one takeaway is, as the external counsel to the company, you have to make abundantly clear ethically. I mean, we're ethically required and obligated as lawyers to make sure that person is aware that his communication to me is not a privileged communication that he holds. It belongs to the company, and that we have the right to disclose it, and that can include disclosing to U.S. authorities. So it adds some complicating factors, and at the end of the day, I think from a U.S. Regulatory perspective, it's a good thing in that it's prodding the DOJ to focus on individual culpability and actually bring, you know, individual people who may have violated the law to justice. It satisfies some of the public's concerns, and it doesn't make the justice system seem like you just go after this big corporation, they pay a bunch of money, and everybody walks away.
Elizabeth, would you like to offer your perspective?
Absolutely. I mean, I think I agree with everything Chris said, and just taking it from my personal experience, in particular working in Brazil and in the region, I think culturally this, and both culturally and legally, this can be really quite a shock to companies that I work with. I mean, basically, you know, what the DOJ is asking companies to do is to help it, assist it in investigating their employees. And that can be quite shocking for companies to understand. You know, we spoke about, you know, how the DOJ has limited ability to reach outside its jurisdiction for evidence. Well, this is another tool that it's put in its tool chest, in addition to cooperating with other governments and to, you know, relying on whistleblowers. It's having the companies themselves help provide it evidence so that it can mount cases against individuals. And so, you know, one part of that is this notion of cooperation, meaning providing evidence about your employees, and that being something that's expected. The other is in your remedial actions that you will take appropriate disciplinary action against individual employees who have engaged in culpable conduct. And that's another area that can be both, I think culturally shocking, but can also be quite difficult, both in terms legally because of differences in labor laws, but also practically speaking for some of the reasons I think Felipe identified, which is that oftentimes in Brazil you'll have either, you're talking about companies where people have been employed for years and years and years, or family-owned enterprises. There's a lot of complicated issues when it comes to employees and to, having this type of cooperation. And I'm not trying to put Felipe on the spot, but I'd be interested in his perspective on that.
Well, just in Brazil, for example, if you are interviewing an employee, you need to do it with open doors, because labor courts can interpret it as some sort of harassment,
Yeah.
right?
That's a good point.
So when you're speaking of legal transplants, of legislations being adopted inspired from one country to another, those legislations, they do not come with the whole system, right?
Right.
They arrive in an already positioned legal system.
Though some employees might say, can we please close the doors? So I'm not sure if we have, how much time do we have left? None? Or 10 minutes? Oh, that's great. I'm doing great. So I'd like to open the floor for questions. And does anyone, not that I still have some more questions here, but happy to take any questions from the audience. Yes, please.
Is it also a concern for Brazilian companies that have bonds or ADRs listed in the U.S. to have these investigations and issues coming out and being revealed by the authorities and then being prosecuted here in the U.S., not only by the DOJ, but like civilly by class actions, which has happened to many of these companies? And how do you advise your clients in relation to that? Because probably they will come out publicly as they are, like the Odebrecht police just came out. So how do you handle that?
Well, my firm represents Petrobras in the securities litigation in the Southern District of New York, so I'm somewhat familiar with the phenomena you're speaking of. No, I mean, I think that's right. If you do have shares listed in the United States, and it's not just that you're subject to the Foreign Corrupt Practices Act, but you could potentially have civil liability in the United States. Now, to be perfectly clear, and this is a law school and we're lawyers, the FCPA doesn't have a private right of action. So in order for shareholders to bring claims against you in the United States, it's typically going to be done under the securities laws of the United States, where they're going to say that, the information that has come out about whatever corrupt allegations are out there, that in some way or other impacted your financial statements, or that, there were false statements that were made to your shareholders, to the investing public, by the company based on these allegations. And so it's not, FCPA violation equals private right of action. It's really, the question just is, whether or not there can be a case made, okay, there was a drop in the stock price, and there were statements that you made about, the integrity of your ethical systems in your company, or some such statement that had an impact on your share price and that was false in some way.
Thank you. Chris, do you want to weigh in?
I think that, you covered it great.
So, in the few minutes left, any other questions? So I'll have a question here for Felipe. Felipe, so you had such an interesting career, having worked for so long with the government and now in private practice, working for a company. Looking ahead, how do you see the Brazilian government, or the enforcement system in Brazil in years from now? Where do you think we're going in the Lava Jato era?
I hope that, so that's a very good question, because you used the right expression, Lava Jato era, right? It's not just the operation. It's all the movements that the federal government in Brazil adopted to prepare prosecutors, prepare investigators, to build a culture of proper prosecution of financial crimes that led to Lava Jato. So I believe that the future brings more cooperation between the agencies, more use of database and data analytics between government organizations. I believe also that we will see more international cooperation, not only the traditional type of cooperation that we had between U.S. or European countries and Brazil, but also South-South cooperation. We have seen that started in the Odebrecht case. So Brazil is going to be now in a position that will be able to actually prosecute transnational crime that happened out of Brazil in other South American or African countries. I see a move of the same culture of prosecution of financial crimes that the federal government has being cascaded down to the state level and to the municipal level, especially because of the BCCA brings this power not only to the federal government but also to other government spheres. And for me, the principal things that we need to change in Brazil were already addressed by the Minister, by the Justice Barroso, which are the review of the privileged forum against top-notch authorities and the review of the statute of limitations so that these people actually get arrested.
Thank you. So let's turn the crystal ball over to Elizabeth. So what about the U.S.? What's going to happen in anti-corruption or government enforcement more broadly under the Trump administration? How do you think the current administration will approach the subject?
Well, it's a little hard to predict with our current president. He hasn't tweeted about it yet, so we don't know for sure.
I think it is in the past.
That's true. In all seriousness, I think we have had, some indications from both the appointments that have been made and statements thus far by officials in the Department of Justice about where we're going to see FCPA enforcement. Sessions during his confirmation hearing assured members of Congress that he intended to enforce the laws of the United States, which is a good thing, as the Attorney General. But in particular, he pointed to the FCPA. As I mentioned, in March, the DOJ announced that it would be extending and further evaluating the FCPA pilot program. And then just this week, Trevor McFadden, who is an acting principal deputy assistant attorney general in the criminal division, made some statements about FCPA and enforcement, indicating that it was something that the DOJ was going to continue to focus on, that there were things that the Department of Justice had, in terms of goals for the FCPA, one being to reduce the length of time that investigations took. He said months instead of years, which is pretty remarkable. I think the median length of FCPA investigations is 4.5 years, so that if that happens would be, going to what Justice Barroso said, that would be really an instance where history would be speeding up quite a bit. In addition, I think this is very relevant for this discussion and for when you talk about Brazil, he talked about the importance of creating a level playing field, which to me, I think, spoke to the U.S. and something that we've seen more and more of as a trend over the last few years, focusing on foreign issuers, saying that we want to create the conditions abroad for U.S. companies, the same conditions for them as are for foreign companies. So to the extent that we can, through cooperating with foreign governments, through our own prosecution of foreign companies, indicate that even if conduct took place abroad, that we're going to go after it to create a more level playing field for U.S. companies, we're going to do that. And so, Again, it is a crystal ball. There's no 100% certainty, and I'd certainly say definitely not with this administration, but that's what we've heard, and I think that's what we're going to see.
Chris?
Yeah, I 100% agree with that. The idea of the level playing field comment, and the idea that, look, there has been, the argument against aggressive enforcement of the FCPA is that it puts U.S. companies at a disadvantage against foreign issuers. So I think the idea that DOJ would try and extend that, to cover that terrain, makes sense. I've heard that as well, but like Lisa said, it's not a crystal ball. I mean, the one thing we have heard from the Attorney General repeatedly, and he issued a memo, is he wants to focus as a priority of the Department of Justice on violent crime, on organized violent crime. A lot of the initiatives that, Attorney General Holder instituted, such as rolling back prosecutors' obligation to file most serious charges in violent crime cases, I think there's an expectation that the new Attorney General is going to basically rescind those. But he's made abundantly clear he wants the Department of Justice to focus and assist local law enforcement with violent crime. What does that mean for purposes of this discussion? There are only so many bodies at the Department of Justice. It's not this monolithic entity sometimes we look at, and individual U.S. attorneys' offices have limited AUSAs and limited resources. That could tip the needle somewhat. FCPA is enforced by a group of attorneys at the main fraud section in D.C., and they assist local U.S. attorneys' offices. I haven't heard anything to suggest that that force is going to be whittled down. I think they'll continue to focus on vigorous FCPA enforcement. But in terms of what's on the Attorney General's mind, that's something he's repeatedly said. Not to say that the FCPA is going to fall away, or that white-collar enforcement will. In fact, I think if anything, individual cases against individual executives for white-collar crimes is going to continue to be vigorously pursued. But, time will tell.
Very good. The comment about leveling the playing field, I think, applies to Brazil maybe in a different way, but one that we see already happening. Because of the Lava Jato, we saw a number of companies exiting the market, some going bankrupt, some reorganizing themselves to try to survive and selling assets, and by virtue of that, we see a number of new players already in the market. So I think in the long run, that will be good for the country, and people are coming not because it is a good commercial opportunity, because they see the enforcement happening. And when they see the enforcement happening, they will have greater trust in our country. So with that, I think we will end. And thank you very much. It's been a pleasure. And let's move to our next panel. Thank you.